The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone, and welcome to this month's webinar, Independent Contractors or Employees, Avoiding Worker Misclassification. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Leon Frierson, the Publications Coordinator for Personnel Concepts, and I'm joined by my co-moderator, Rosie Merlan, who serves as our Senior Regulatory Researcher.
Hello to all of our attendees. I'd like to welcome Zachary James as our guest speaker. Zachary is a sole practitioner business attorney located in Chicago, Illinois, a graduate of the University of Michigan Law School. He has worked in private practice as well as the SEC Office of Small Business Policy. His practice focuses on business compliance, employment law, corporate governance, and securities. Thank you, Zachary, for joining us today.
Thanks for having me, Rosie. Classifying workers, it's a topic that clients come to me very frequently with. There's a lot of misperceptions of it out there, so I'm excited to talk to your viewers about it today.
Definitely. We're looking forward to discussing it with you. Today's agenda focuses on providing an overview of worker misclassification. We will begin with a look at why proper classification is important. Zachary will then discuss classification and the various tests used by agencies to determine whether a worker is an employee or independent contractor. We will then examine recent legal developments affecting classification, including how the COVID-19 crisis has affected business decisions regarding employees and contractors. Finally, Zachary will go over steps employers can take to ensure that they properly classify workers. And at the end, we'll address questions submitted by our listeners.
The format for today's webinar features a series of questions that I'll be asking to Zachary regarding the duties test used to determine whether a worker is an independent contractor or an employee. Before we begin, I want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the question window. Most questions will be saved for the end of today's session, but those that are relevant to the subtopic being discussed will be posed where appropriate. Then at the end of the session, you'll have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. With that, let's get started with today's presentation.
Okay, Zachary, classification of workers has certainly been a hot topic lately, especially with the growing gig economy and the structural changes many businesses have had to make during the COVID-19 pandemic. Why has government agencies been so focused on enforcement of this area of law in recent years?
Well, Rosie, see, classifying workers as an independent contractor, it's a common tactic that businesses use to save money on a lot of different areas. So it
Looks like we may have dropped Zachary there. Rosie, are you hearing anything from Zach?
I cannot hear Zachary at the moment.
Okay, well, we'll try to get him back on the line. How about we just go to our first poll question and see if we can get him back on the line. In fact, we have two for our audience.
Yes, okay, thanks, Leon. We do have two quick poll questions to gain a better understanding of who is in attendance. For our audience, let's go ahead and share this first question. Okay. Does your business currently utilize independent contractors? And please go ahead and make a selection of yes or no. Okay, looks like the votes are coming in. Looks like votes are still coming in. Okay, let's go ahead and close that out and share the results. So it looks like mostly all of you do utilize currently utilize independent contractors. Now we're going to go ahead and do another quick poll question. Is your business in an industry where independent contractor classification is currently a hot topic? We have yes, no, or not sure. Okay, votes are coming in. Votes are still coming in. Okay, let's go ahead and close that poll and share our results. Oh, okay, so this one seems like there's all over the board. So there's yes, no, and not sure. Okay.
All right, audience, and it seems like we are still having some technical difficulties. Obviously, we want to deliver the best webinar to you today with our expert attorney on the line. So we'll give him a few minutes and see if we can get him back on. If not, we'll either have to have a makeup webinar or send you guys the recorded session. Absolutely, we want to get the information out to you guys today, and I'm already receiving some questions that are pretty important, especially I have one from Edward here. He's asking about the PP program and how that applies to him as far as an independent contractor. So we want to make sure that you guys do get the answers to your very important questions today. Can I get some feedback from the audience? I see some of you guys are typing. Were any of you guys able to hear Zachary through his first messaging, or did it just cut out during the first slide? Because that's what happened on our end, but right. Thank you, Alejandra. Kate. Couldn't hear him initially, then he cut out. So yeah, it seems like we're having a little issues. If you guys want to just hold on for maybe about 60 seconds, we'll try to contact him and see if we can get him to come back in, because it is a very good presentation that we have for you today. And then the worst comes to worst, we'll send it to you guys as far as for an on-demand webinar or put it up on our YouTube. Just wait about 60 seconds. I'm going to contact him offline and then see if we can get back started again.
Hey, everyone.
Thank you.
Can you guys hear me now?
Yep.
Perfect. Actually, there he is, you guys.
Sorry.
Glad
It's been raining here all day, and it finally put out the internet.
No, we're just glad to have you back, Zach. So we actually just went through the first two poll questions. We have some responses back from our audiences. So if we could just pick up with tax considerations, and Zachary, could you just review for us some of the
Sure.
reasons why it is important that workers are properly classified?
Sure. So there's four main reasons, or four main factors to think about when you're classifying employees or workers. So classifying someone as an independent contractor, you should think about tax consequences, employment law considerations, and then your accounting and reporting requirements. And then classifying a worker as an employee, you should think about your agency considerations. But summarily, most people are going to want to classify a worker as an independent contractor because it's cheaper, lower taxes and accounting costs. And then administratively, it's just a lot simpler. You only need to hand them a check for most instances, maybe file an annual 1099 if the amount's over $600. But that payoff, that huge amount of savings that you can have is a double-edged sword, right? That's money coming right out of the IRS's pocket. And 72% of the US tax revenue comes from payroll expenses. So the IRS and the other agencies, they're very keen on keeping track of who's filing, who's trying to misclassify workers, and getting as much money as possible. So, right, they had an initiative back in 2009, and just with that one initiative, collected an extra $172 million in revenue just in that year alone. So we did this first poll question. So the first of those considerations that would be tax, right? Proper classification affects your taxes. Employers, they must pay certain taxes for employees, but not independent contractors. Those are Social Security taxes, federal unemployment taxes, workers' compensation, Medicare, and then any specific state and local taxes that there are. The next consideration, the next independent contractor consideration is employment law. So employment law, it's one of the most confusing sets of law there is. There are attorneys who make hundreds of dollars an hour, and all they do is make sure you comply with regulations. The regulations, you got to think about just a few you have to think about. It's the National Labor Relations Act, minimum wage laws, overtime laws, workers' compensation laws, and then workplace discrimination laws, including EEOC regulations. On the other hand, independent contractor law, it's pretty much just whatever you draft into the four corners of the document. There's no real overarching regulatory body that oversees the independent contractor employer relationship. The next major consideration is the reporting requirements. So if you have an employee, it's much simpler to have an independent contractor. Employers basically just have to send them an annual 1099 for amounts over $600, and then the independent contractor is responsible for filing their own taxes. The employer doesn't have to withhold anything, calculate any amounts. It's just send them the 1099, and that's the end of it. For employees, though, there's at least quarterly 941 filings on the federal level. Most often, those are weekly filings. Then also your annual W-2 filings. And basically, you have to double up on all of those at the state level and sometimes at the county level also. So those three reasons, tax, employment law, and reporting requirements, are why you'd want to classify a worker as an independent contractor. But going the other way, there is a reason why you'd want to classify a worker as an employee, and that's agency considerations. So an employee is an agent of the principal. They're an agent of the company they work for. That means they have fiduciary duties, the duty of loyalty and care for their employer. Whereas the independent contractor, they're just a market participant, and they're only bound by what's in the contract. So how that usually plays out is that automatically employees are legally not allowed to take business away from the employer when they leave. So if you have a salesman, he can't take his clients with him when he goes to another agency. They also can't steal trade secrets, IP secrets. And then the employee is bound to act with a duty of care. They have to act in a reasonably prudent manner based off of the standards of that industry. So a higher standard than just the public. They have to act in a way that someone skilled and expert in their position would act. The other consideration with agency consideration, is that employees, being agents, they can bind the employer and contract and tort. So the common example here is a bouncer at a bar, right? If that bouncer, he gets a little physical with someone and throwing them out injures them, the bar that employs him is automatically liable for those actions, even if it was outside the course of the business. So these are all reasons you need to consider how you're going to classify your employee, and it's easy to see why there are these benefits. There's these huge savings to them, so it's easy to see why employers are going to want to classify workers as independent contractors. But the penalties for getting caught are just as big. So next slide. I think we got a little off here.
Okay, yeah, those are definitely important reasons to make a proper distinction between an employee and an independent contractor. It's easy to see that there are several benefits to the employer of having an independent contractor rather than an employee. What are the consequences of an employer misclassifying a worker?
Sure. So if you're caught, you're not only liable for all the back tax or all the back payments you owed, you also need to pay interest on them. So misclassifying someone 5 years ago, it's not just a small payment that you've saved for 5 years, it's earning interest that entire time. You're also liable for up to 20% of the wages paid. So that's the wages not paid, as well as the wages that you did pay as a penalty. And then there's also criminal fines of up to $1,000, and you can even face prison time for it, for misclassifying an employee. So these amounts, they add up pretty quickly, right? So there's a lot of class action lawyers who are out looking for these types of violations. And that's the real risk here, is that there's lawyers who maybe each employee isn't going to make a huge amount of money, but these lawyers can put together 20, 30, 1,000 of these employees, and the payouts get to be in the millions of dollars very quickly. So one example of this, California truck drivers a few years ago, there was a class action for 896 employees that was settled for $9.25 million. That's over $10,000 per employee, $10,000 in penalties per employee. And Uber just had to settle for a lawsuit for 25,000 drivers for $100 million. So that's over $8,000 per employee.
Wow, okay, thank you for that information, Zachary. And before we move on to discussing how to properly classify a worker, let's do another audience poll. Okay, so for our audience, on a scale of 1 to 5, how confident do you feel about properly classifying workers as independent contractors? not confident, not very confident, somewhat confident, 4 is confident, and then 5 is very confident. Okay, it looks like votes are coming in from 1 to 5, with 1 being not confident and 5 being very confident. Okay, and it looks like we got most of our votes in, so let's go ahead and close that and share our results. Okay, so it looks like most of you are somewhat confident and confident.
Yeah, thank you guys. Thank you guys for the audience for participating in that survey. And I think with you guys being pretty confident, hopefully you'll be able to get some good information out of this next section. Zachary, could you give our audience a brief overview of agencies that are responsible for enforcing worker classification and the test that they use to determine whether a worker is an employee or an independent contractor?
Sure, Leon. So the IRS oversees the tax matters with employee classifications, obviously, but then there's the Department of Labor and the National Labor Relations Board, who oversee the classification for employment matters. These, the IRS has one test, the 20-factor test, and then the Department of Labor and the National Labor Relations Board use the economic reality test. In practice, these are pretty similar tests, but they're not the exact same. There are some nuanced differences between them. So classification as an employer under one is you're not certain to be classified as an employee under the other. So, and the important thing to note with these tests is that there's summation of all factors. There's always going to be gray area here. It's a qualitative test, and these are just a lot of considerations. It's not a, if you have more pro-employee class or factors than pro-independent contractor factors, you're an employee. It's a gray area where you have to make some judgment calls to figure out where exactly your worker stands. So the IRS 20-factor test, that's a common law test. It's what's the traditional historical test of the United States. And like there's obviously 20 factors there. The first one is the level of instruction. So independent contractors, they should just be just that independent. They should be their own business. They should have control over how they do the work, right? If you hire someone to, you know, an electrician to come in and put in a new panel for you, you're just concerned that the panel works when the day's done, not how he put it in, and you're not going to tell him how to do his work. And so this instruction, it can be oral, but then it can also be handbooks, written procedures, basically any kind of instruction. The next factor is the amount of training. So very similar to the level of instruction, independent contractors should already know how to do the job, or if they need to learn it, they're learning it on their own. It's not a skill that the employer has within its own enterprise. The next factor, degree of integration. Once again, independent contractors, they're independent, so they should be their own standalone for-profit business. If they're relying on the employer for stuff like accounting, back-end work, support, they're not really, they're too integrated with the employer, so they're not really independent. The next two factors are choice of agent and choice of assistance. So once again, and this is a common trend, the independent contractor being independent, being their own standalone business, they should have the ability to choose which employee within their own business gets the work done. They should be able to choose their own agent. And similarly, control of assistance, if the employer, if the independent contractor is using employees of the employer as their assistants, as their agents, they're not truly independent. So the good example here is a lawyer, right? If I'm an independent contractor as a lawyer for a firm, but my secretary is an employee of the firm, I'm not truly an independent contractor under this control of assistant test. The next factor is continuity of relationship. So once again, when you hire a independent contractor to do a job, you're hiring him for that job, right? We hired that electrician to come in and install a panel for us. But if we hire an electrician to do all of our electrical problems in all of our buildings all of the time, that's not really a one-off project. It's an ongoing relationship, and that's more indicative of an employee-employer relationship. The next two test factors, flexibility of schedule and full-time workload. So the independent contractor, they should be able to control their own work hours, right? Once the employer is only concerned with the end product, not how that end gets reached. So the independent contractor, they should be able to determine when they're actually working. And full-time workload. So as an independent contractor, as an independent business, you should be able to go out and look for other business. But if you have a full-time workload, then you obviously can't do that. All of your work is tied up with one employer, and you're more akin to an employee of that employer than an independent contractor. The next factor is requesting on-site work or just working on-site. So obviously there's some work that has to be on-site, right? That electrician has to install the panel in place. But if it's work that does not need to be on-site, but the employer requires the independent contractor to be in site, that's more of an employee-employer relationship because it shows that level of control over how the work is done. The next two factors is sequence of performance and the reporting requirements. So, right, the employer should only be concerned with the end product, not how that work is done. So controlling the steps and how that work is done shows a level of control that an independent contractor should have. And then reporting, making someone report those steps taken, once it also indicates an employee-employer relationship. The next factor is method of payment. So with the independent contractor-employer relationship, right, we're only concerned with the end goal and that the end product is delivered. So a single fixed payment or scheduled fixed payments are more indicative of an independent contractor-employer relationship rather than a salary or an hourly worker, where those are time-based payments, not the work product-based payments. The next four factors, these are all just trying to encompass the fact that the independent contractor should be their own independent business. They are payment of expenses, providing tools and materials, investment in facilities and in equipment, and then realization of profit and loss, right? If a business is truly independent, they should have their own assets. They should have their own factories. They should have their own tools. And they should be at risk of doing a bad job and losing money, but they should also have the chance for upside gain above and beyond just a wage. They should actually be able or have the opportunity to realize real profits. The next two factors are number of clients and availability to public. So with that independent contractor actually being an independent standalone business, he needs to be able to go out and drum up business from other places, right? Having one source of cash flow for a business is not a very good business model. So if that independent contractor has multiple clients, it's indicative of a better business model, more likely an actual ongoing independent business. And then availability to public, that's just holding oneself out as trying to get multiple clients. The final two factors are control over discharge and right of termination and to quit. So employment law having a huge breadth of law behind it, there are rules, set rules as to how an employee is fired, how they can quit, right? 30 days notice. Most employment in the US is employment at will. Firing for any reason or no reason at all can happen immediately. Now, the independent contractor, they have specific termination language drafted into the contract, right? With that electrician, if he buys, usually that contract will say, well, if he spent $200 on materials and then I fire him, I've still got to reimburse him the cost of those materials, or he has the right to complete the job. So how you can hire and fire an employee and how that worker can quit gives a lot of insight into the actual classification of that employee. So that's the IRS 20-factor test.
And thank you for going through each of those tests, each of those steps. Very informative. But from what I understand, the IRS 20 factor has been used for many years, but they're also most recently focusing on the three overall factors relating to the degree of control or type of relationship. What's the difference between these three factors and the common law 20 factor test?
Yeah, so what the IRS is trying to do with this new 3-factor test, behavioral, financial, and then the type of relationship, is basically take those 20 factors and boil them down to 3 qualitative categories, right? It's kind of onerous going through all those 20 factors, and it could get confusing that we qualify under some and some of the other ones. So what the IRS is just trying to simplify this with these 3 new factors. So there's behavioral, and that's basically the control over how work is done factors, right? The training, the integration into the workforce, and then control over the method of work. There's financial control. So that's trying to make sure that the worker is actually an independent standalone business. So those are like the providing tools and materials, investment in facilities and equipment, realization of profit and loss. And then the final factor is type of relationship. And that's just looking to the legal structure, right? Is there actual profit and loss potential of the independent contractor? Are they actually a standalone business in the legal sense? What are the hiring and firing mechanisms for that worker? In addition, the IRS lets employers treat workers as independent contractors if there's a reasonable basis for such a treatment, right? The IRS, they're more concerned with catching the people trying to cheat the system, not the people who just made mistakes. So if you can find a reasonable basis, then the IRS is going to give you a little more leniency. That reasonable basis, it can be an IRS ruling, it can be a technical advice memorandum, an SSA, and it can be an IRS payroll audit that happened in the past that found that similar workers were employees, not independent contractors, and then also widely recognized and established industry practices. So that's the IRS standard, right? The 20-factor test, and then the 3 factors behind it with the reasonable basis, safe harbor. The Fair Labor Standards Act is applies the economic reality test, and that's what the Department of Labor and the National Labor Relations Board applies as far as minimum wage, overtime, record keeping, and other employment laws. Once again, this is very similar to the 20-factor test when you think about the factors. They're just slightly different in some aspects. So the first aspect is, are the services offered by the independent contractor similar to the principal business of the employer? So here, think Uber, right? Their drivers are independent contractors, but Uber's business is putting people in cars. So under this factor, Uber drivers are more of an employee than an independent contractor. The next factor is the permanency of the relationship, right? Ongoing, without a actual termination date, into perpetuity relationships are more indicative of hiring someone as an employee rather than hiring someone as an independent contractor. Fourth factor is investment of the contractor in his own equipment, right? Is it actually a standalone for-profit business? The next factor is who controls the nature and the degree of how the work is done, right? That's that behavioral day-to-day control that's in a lot of the 20 factors. Next factor is profit and loss sharing. Once again, is that contractor a standalone business where he's at the risk of actually losing money, but also has the chance to make money above just a wage? Next factor is the competitiveness of the market for the services, right? If this is actually an independent for-profit business, there should be more than one company offering this service, right? There are lots of electricians out there because that industry is a profitable industry to be in. And then the final factor is the legal and the operational independence, right? Is it actually legally an independent standalone business? They have their own LLC or incorporation. And in addition to the factors that the economic reality test actually includes, they actually exclude a few factors. And what these are is basically saying, this is exactly how we're different than the 20-factor test. The first factor that the economic reality test excludes is the location where the work is performed. The next factor is the existence of an employment agreement, right? The Department of Labor, what they've said here is that you can draft any language into the employment agreement, and it's usually the employee has to take it. There's not too much negotiation on a lot of the terms in a lot of instances, so we're just not going to consider that at all. The Department of Labor and the National Labor Relations Board also does not include or consider state licensing, right? Just the fact that that electrician has to be licensed at the state level as well as the local level is not indicative of him being independent, right? As a lawyer, I have to be licensed I have to be barred. That is no indication of me being an independent contractor. And then they also don't consider time and mode of payment. This is, I think, in this instance, what they saw was that there's just too much confusion here, right? You can see how an electrician is paid for the job, but lawyers are usually paid hourly. And just for that confusion alone, they decided not to consider it at all.
Thank you for that in-depth explanation, Zachary. And we've got tons of questions about people's specific experiences in their workplaces. And so I did want to bring someone in now just to give an example. She's sounds like she may be an owner of a small business, and I'll let her speak for herself, but that does represent a big part of our customer base. And Candy, if you're there, can you go ahead and pose the question that we spoke about in the chat window? Candy, are you there?
I am.
Hey,
Hi,
thank
Candy.
you for coming in.
Hello. I am.
Yes, yeah, go ahead and pose the question. I saw you went a little bit more in depth, but then your original question about the 50% owner was, I think, intriguing for our audience.
Why don't you go on to the next question first? I'm not prepared to ask my question yet.
Okay, sure. No, thank you for coming on. Appreciate that.
Okay.
You know,
So,
if I can jump in just for a second, I kind of
oh,
just from what I heard. So 50% ownership, that's an interesting situation. So
right, and I can pose the exact question I was thinking. If she said, can a 50% owner of a business be a contractor as well? And that's what I was looking to lead to.
sure. So in that instance, yes, I mean, it could be possible, but in that instance, to save tax money, there's better ways to do it. Usually, right, as a standalone business, you can, instead of paying that 50% owner in salary, you pay him a lower salary, minimize your tax burden, classify them as an employee, minimize your tax burden by paying them a lower salary, if any salary at all, and then paying more in dividends and distributions. So that would be that's an interesting question in theory, but in practice, it does not come up that much because there's better ways to do it.
No,
Okay.
well, thank you for that.
Yeah, thank you, Zachary. That's interesting. Now, in addition to the IRS and FLSA tests, I know that there have been some recent legal developments that affect worker classification as well. Could you give us some highlights of how that changes some highlights of the changes that employers should take into account in regards to that?
Sure. So most of the changes to these standards in the past few years have been due to the rise in the gig economy. So that's the hiring of freelancers, you know, Uber drivers, freelancer.com, Upwork.com, Airbnb, people who are deriving all of their revenue from a single business, but under the traditional standards, they're more like an independent contractor than an employee. And the states as well as the federal government are concerned with this because it is becoming a growing portion of the economy. So revenue sources for the government are shrinking and shrinking every year. Most of the developments have been on the state level. Most notably is California's AB5 law. And what the AB5 law does is create a presumption that workers are employees until proven otherwise. So historically, when we were trying to classify a worker as an independent contractor, we were neutral from the beginning. A factor would take us one way and the next factor would take us the other way. Now the burden is on the employer to prove that the worker is an independent contractor. It's a higher burden to not have to pay those taxes. And the test is also more onerous. It's no longer just a qualitative summation of all the factors, it's an all or nothing. You have to have all of these categories in order to be an independent contractor. The categories under the AB5 test are no direct control, so right, no behavioral control over the day-to-day work of the worker. It has to be outside the usual course of business of the employer. So this is directly attacking Airbnb and Uber. And the customs of the trade, so the industry standards, is that of the worker being classified as an independent contractor. And this one's very interesting because what this means is that you could have no new independent contractors, right? If someone comes out with the next Airbnb, it's impossible that the customs for that new business, that non-existent independent contractor, was to qualify that worker as an independent contractor, right? It had no longer existed before. So under the AB5 test, what they're basically saying is independent contractors now are still independent contractors, no new ones allowed. Federally, there hasn't really been too much to this. The IRS has not commented on the AB5 law. The Department of Labor and the National Relations Board have came out and commented on it, and they said that we not disregard completely, but we're not going to pay any weight to the AB5 type standards and the growth of the gig economy just yet. The other major state change is New York City. They set basically a much more heavy-handed measurement or regulation than the AB5 law. They basically said if you're Uber, if you have drivers, they have to make at least $27.86 per hour before expenses, right? Basically, they came out and said yellow cab companies, the cornerstone of New York, we're going to protect those guys and set a higher labor rate for Uber. Obviously, the industry is pushing back on this, right? Uber, Airbnb, the huge lobbying departments, legions of lawyers, and they're trying to revamp this standard, specifically in California. And what industry is suggesting we do is create a sliding scale standard. So on one end, we have independent contractors where the employer basically owes them no liability or no support, no insurance, no medical insurance, and nothing like that. And on the other hand, we have employees, or on the other end of the scale, we have employees who have full benefits. And then somewhere in between, in that gray area, we have a new category called the dependent workers. And these people, they can be anywhere, and the amount of benefits owed to these workers is based off of the hours they work, right? So a dependent worker working for Uber, maybe driving 4 hours a month, they're basically an independent contractor, right? Owed no benefits. But if that worker is working 40 hours a week, 50 hours a week, they're much closer to an employee, and they're not owed all of the benefits of an employee because they're not an employee under the traditional tests, but they're owed a lot more benefits.
Thanks, Zachary. And do you have any recommendations of steps employers can take to ensure they properly classify workers?
Sure, Leon. The most basic thing you can do is file a Form SS8 with the IRS that exempts you under the reasonable basis test. And what you do there is you take it's a form of the IRS 20 factors, and you write a few sentences about your specific situation for each of the factors. And then the IRS will come back and make a decision for you, and you can rely on that decision. The only problem with filing an SS8 is that it usually takes 6 months. So it's, right, if you want to hire someone in the next few weeks, few days, the SS8 is not the most timely option. The other suggestion I have is make sure you qualify for Section 530 relief from the IRS. So this is very similar. It's a growth of that reasonable basis test relief. And what the IRS is saying here is that we're not trying to catch the people who mistakenly misclassify workers. We're trying to catch the purposeful violators. So if all your federal tax returns have been timely filed and the employee has been treated as an independent contractor on all of those filings, and the employer has treated all of their employees, all of their similar employees as independent contractors, and a reasonable basis, one of those reasonable basis factors we talked about earlier applies, then the IRS is not going to pursue you even if that worker is misclassified. The other suggestion I have is that when you do employment agreements, make sure you draft specific independent contractor, or I guess independent contractor agreements, not employment agreements. Make sure you draft specific independent contractor language into that agreement. While the Department of Labor and the National Labor Relations Board won't look at that, the IRS will look at that, and it's fairly simple to do, right? Just go down this list of 20 factors and say that, right, this is non-exclusive. The worker can go out and find other work. That the worker has to supply his own materials, right? It's very basic stuff that no one's going to really argue over, but gives you a little more legal protection. The last suggestion I have for workers is that, or for employers, is pay attention to what state your worker is in. The governing state law for how that employee is classified is based off of his location, not the employer's location, and consider the political environment of that state, right? California has strict laws. There are states nearby, Washington, for instance, who are considering very similar tests. Whereas, workers in the Midwest, it's not as likely that we'll see changes like that in the near future.
Okay, thank you, Zachary, for that. And before we move on to our last section, let's do another quick poll for our audience. Does your business plan to increase usage of independent contractors during the COVID-19 pandemic? Yes, no, or you're not sure, you're still deciding. Okay, there's still a few more votes coming in. There's still a few more of you voting. Okay, so let's go ahead and close that and share results. Okay, so it looks like most of you said no to that question. And Zachary, can you explain how COVID-19 is impacting the issues of employees and independent contractors?
Sure, Rosie. So I think there's actually a silver lining chance here to reclassify a lot of employees as independent contractors, right? There's a chance that now that everyone's working from home, a lot of these factors are no longer satisfied, right? The managers have less day-to-day control over a worker who's not in the office, and the worker, one of the factors is the worker in the office. So there's an opportunity to look at some of these employees who were very close to independent contractors in the past and see if now, if you leave them working at home going into the future, if they can be independent contractors, and you can save a lot of tax liability there. The other point I'd like to make is that the PPP program is based off of employee salary. So this kind of came back to bite some of those people. The PPP program, it's based off of your W-2s. So this kind of came back to bite a bunch of people who would misclassify workers as independent contractors to save taxes, right? They're not getting this government bailout because they don't have as much employment dollars to collect on. Then the final point is that stimulus for gig workers has been included. So stimulus for independent contractors has been included in this first PPP program, and it's been temporarily included. We don't know if it's going to continue into the future, but it is possible that going into the future, there's going to be more government support for unemployment, similar support for gig workers. So taxes on independent contractors, those gig workers, might actually increase at some point in the near future.
Thank you, Zachary. That's definitely some current, trending topic right now surrounding that. And we would like to do one final poll question for our audience. Based on what we have reviewed today, how confident do you feel now about properly classifying workers as independent contractors? And on a scale of 1 to 5, we have still not confident, that's 1. 2, not very confident. 3 is middle of the road, somewhat confident. 4 is more confident. And 5 is if you're highly confident. Okay, we have a few more votes still coming in, so we'll give everyone another quick moment to answer that. Okay, let's go ahead and close that and share results. So based on today, you feel more confident, somewhat confident, and highly confident.
All right, thank you, Rosie, and thank you again, audience, for participating in that survey. And before we end today's session, let's take a moment to answer some of the questions that we did receive from our audience that were submitted during the presentation, and we got tons of them, so thank you guys for that. I want to start off with a question regarding nonprofit organizations, because we did get a few of those. Bill asks, are there any unique issues that must be considered related to nonprofit organizations regarding independent contractors versus employees?
So technically, there's no difference, right? The standards are the same. They don't make a distinction between who the employer is. Practically, you may get a little more IRS leeway in misclassifying workers if you actually are a true charity.
Okay, and then I have a little bit of a specific instance here. Elena asks, we are a local nonprofit and have a few practitioners who run our programs and trainings. Their work is project-based and they get paid on project basis whenever the client pays. Practitioners might have 1 to 100 projects per year. And on one hand, they check all the marks of being an employee based on their duties, but they are not full-time employees since their work is project-based and they are signing a contract for each project. How should we qualify the practitioners? And they are a nonprofit as well.
Sure. So this is one of those answers that would take a 30, 40-minute conversation to really get down to. But sure, from what I hear, it's project-based, but they're doing a lot of projects. So my initial questions would be, what does their scheduling look like, right? Are they working in the office full-time? Are these people, are they overseen by a project manager? Or is it more like you're hiring an executive who's coming in part-time and doing this all on their own? They're using their significant skills learned elsewhere to sort of be in the executive branch of the not-for-profit.
Oh, Oh, thank you. And then I have another question, a question from Joanne, and it sounds like she's in the nursing or the medical industry. And she asked, what about nurses in a nursing facility? CNAs of the facility may report to an independent contractor, and nurses are required to report on the work accomplished during a shift. I don't know if you're familiar with that and how it plays into independent contractors.
Sure. So let me think this through. So in this instance, the nurse is an employee, and the manager that they're reporting to is an independent contractor. And I've seen this instance actually in practice before. This is one of those instances where it's probably a misclassification, right? This gets back to that control of assistance factor, which is it's a pretty determinative factor in itself. I believe the IRS puts a lot of weight on it, right? What's basically happening here is that the facility is saying, okay, this manager is making the higher salary, so we can save a little money and classify them as an independent contractor. But the fact that they're managing employees and they're involved in so they're heavily involved in the day-to-day interaction of the company, the management of it, they should probably be classified as employees rather than independent contractors.
All right, thank you for that recommendation. And then I'm going to kind of group Angie and Elizabeth's question together. They're talking about, I believe, reclassifying employees in a way. Angie asks, if an employer hires someone as a 1099 independent contractor to see if they want to hire them, if they do well, what is good documentation to show that they were originally an INC and then became an employee and something that will stand up under an audit?
Sure, this is a pretty common tactic, right? People don't want to file all that paperwork to onboard an employee until they know they really want that employee. Unfortunately, it's often a misclassification, right? If the duties of that employee, or when we're looking at all these factors, the time is only one of them, right? The length of employment there, and that length of employment factor, it's not really applicable to the situation. That length of employment is the intended length of employment. When you hire that employee for that initial trial stage, you intend for them to work full-time as an employee. So unless you can actually go back and look at these categories and see shifts that would substantively allow for requalification, that part-time or that trial worker should be an employee from the beginning. So if you are classifying as someone as an independent contractor and hiring them as employee, my suggestion would be to go back, look at the IRS 20-factor test, and look how you can check the boxes as an independent contractor in the first instance, and then how the responsibilities can shift to employee in the second instance, and restructure, actually, substantively restructure the work that that employee does so you're properly qualified or classified.
And then to follow up with Elizabeth's question, if you, in the case that you do have a misclassification, what should the employer do if he or she misclassifies an independent contractor? What are the steps to take to fix it?
So it depends on the length of the classification, or the length of a misclassification, the time length, as well as the severity of the actual penalties. In most instances, a reclassification, as long as you start paying them again and it's not huge dollar amounts, you're going to be okay.
All right, and then I have two questions here related to churches. I think it's Cleoletta, if I'm pronouncing it correctly. It just says, hey, do these rules apply to churches? So that's one. And then I have a specific instance about some musicians that are classified as independent contractors, and she just wants to know if she's doing that correctly.
Yeah, so churches, as a not-for-profit, they are subject to these regulations. And then musicians, without, obviously, this would be something you need to discuss with the attorney and really go through the whole test and know for sure. But, right, if every Sunday someone's coming in, playing some songs, and then you pay them $20, $30, that sounds like an independent contractor relationship.
All right. And then, see here, I had another question that actually follows up with that pretty well as well. Robert asks, as a litmus test, if someone has to bid on a job at the location, wouldn't they be considered an independent contractor? I guess that kind of plays into musicians.
Yeah, so just requiring someone to bid alone might not do it, but if you're having multiple people bid on that job, that's showing a competitive marketplace for the business that that person's offering. And so that is pretty indicative of an independent contractor relationship.
All right, and then I just have one final question, and then I want to assure the audience that we will be sending out the entire presentation to you all, including the slides and the recorded webinar that you hear today. And then any other questions, we'll make sure that we get them over to Zach, and they'll be emailed to you. But this one is concerning, it's pretty timely, concerning the PPP, and Edward had and a concern here. He said he tried applying for the PPP program. My banker said it excluded independent contractors, which comprises my total staff count. I was not eligible. Then 2 of my independent contractors filed for unemployment and were approved. That flies in the face of all the independent contractor versus employee rules. He doesn't understand. Do you have any thoughts about that, and why they may have been approved and he wasn't?
Yeah, so his business had no employees to collect or at least that's very few employees to collect the PPP program, right? Because the PPP program is to pay wages. But because everyone was independent contractors, he did not have any wages to collect on. Now, those independent contractors, they are their own business and they have wages on it. And the definition of wage is sort of different for those gig economy workers. And that was a change made in this specific instance. But them as their own businesses with quote unquote employees, they can collect on those employees.
All right. Well, thank you, Zachary. That was very informative. And I want to thank the entire audience for sticking with us through the technical difficulties. Obviously, there's tons of people online staying at home right now. So hopefully that was the source of the issue, because we're pretty spot free. And I think we did a great job bouncing back. So kudos to the team and everyone that's online. And thank you, Zachary, for presenting for us today. Unfortunately, we have run out of time. Like I mentioned, all unanswered questions will be forwarded to Zachary via email, and his response will be sent to all attendees in the next coming days. And thanks to everyone who did submit questions about today's topic, and thank you to Zachary for answering them.
Okay, thank you, Zachary. Thank you, Leon. We enjoy hosting webinars for our valued customers, and as such, would really appreciate your feedback. Please stick around just for a couple of minutes as a brief survey will open up for you to rate what you saw and heard today. This concludes today's webinar. Thank you for attending our presentation. We hope you found this information useful in understanding worker classification. Thanks again to Zachary for being our guest panelist. We look forward to continuing to work with Zachary on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. To all of our attendees, thank you for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.